Hey, what's up, everybody? This is Wednesday evening, and it is time to do your agent prep, exam prep, study for your exam to take your real estate exam for your real estate license in the state of Texas. Some of the review is also for national, so anybody that wants to review it for national, after I do the questions. Okay, so you're going to see right here, this is one of the sources that I use. It is the Texas Real Estate Sales Exam Guide. It's a 4th edition by Learning Express. It's a really old source from 2006. However, it is an awesome source. So when any of you come on, say good afternoon, okay? So we should be live both on Facebook and on YouTube. And so I ended up getting a membership to this so that it is also recorded. I can download it and share. Now, in order for me to see your comments, you'll have to, how does this work here? You'll have to let StreamYard, you have to give permission to StreamYard, okay, in order to see your comments. And let's see here. You need to go to StreamYard, StreamYard.com. Let me see. Okay. So you'll need to go to StreamYard.com and then give him permission so that I know who is commenting and your name will show up here. Okay, like right here, it shows StreamYard and live view comments show up on StreamYard. This is an example. So so here I typed, so this is the YouTube channel where you can also watch the videos. And so when I typed good afternoon, okay, it shows it up here because I've given StreamYard permission to connect Facebook and allow you to comment. Okay, let me see if I can tell you the link for StreamYard that you can, StreamYard comments, okay. So hold on, let me, grant Facebook access. Okay, the way you do it is you go to StreamYard.com/Facebook. Okay, so go to that link right there and grant StreamYard permission to allow your comments to be posted so that I know who it is. Okay. And you may end up having to go into settings. I had to do that, go into my settings to the apps, and then searching for StreamYard and then giving StreamYard permission in the settings, okay? All right, so let's get going where I was at. Okay, so this is the source that we're using. The glossary, table of contents. So this is just one of the sources. For those of you that have been with me for a while, we've been using this, and I consecutively start from one point, go to the other. We already did all the national, all the state. We're doing right now glossary. The reason why I love this and the other 2 sources that I have bought that we are using is that it gives you a little preparation, talks to you about what the sales exam is. It has 4 exams of 110 questions, exam 1, 2, 3, and 4. And now, of course, you have more questions than that. You have 85 national and 40 state, right? So that's 125. But these exams are 110 questions. The first 80 are national and the last 30 are state. They're awesome, awesome, awesome. A few are outdated, but that's, so it'll trick you. It'll let you know whether you know the material or not. It has a math review and it has glossary, which is critical, 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 okay, for you to know the glossary, okay, because the glossary helps you answer a lot of questions, okay? It requires for you to study every day, even if it's 30 minutes, an hour, 45 minutes, however much you can study or listen. Vocabulary is the first thing that you should study, and then go to questions. So last week, we finished off with, let's see, we're starting with estate on page 1163. Okay, we finished off with escrow disbursement. And so we're starting with estate. And so we typically do about 40 minutes, 35 minutes of each. So we do first vocabulary, then we go into national questions, and then we do state. Okay. And while you're here, okay, hey, say hello and give me your name if you haven't given StreamYard or Facebook permission. Again, the link that I just posted that you need to go to is StreamYard.com/give Facebook permission, and then it'll end up showing who is making the comment and your picture. Okay, so with that said, let's move on, move right along. Okay. So, bear with me because I am, this is the second time that I use StreamYard, and it's being broadcasted to Facebook and also to YouTube at the same time. Okay, vocabulary, estate. An interest in real property, the sum total of all the real property and personal property owned by an individual. So just the word estate means you have an interest in real property. Okay, so real estate, you have an interest in real estate property. Okay, not personal property, but real property. So just the word estate means you have an interest. Okay, and it could be 100% interest, 50% interest when you own it with somebody else. So it depends how the property was purchased. So it's the sum total of all the real property and personal property owned by an individual. Okay, or it could be a entity, right? An entity is considered as one severalty, right? 4 different types of ownership is one severalty. It's one person or an entity. Tenants in common, 2 or more individuals that have common interest or joint interest in property, but they don't have to have the same percentage ownership, but they have 100% interest, which means they have 100% possession of the whole property. But they might own 60-40, 50-50, 30-70. So 2 or more people, tenants in common, they didn't have to acquire it at the same time. Then another type of real property ownership and interested in estate, okay, it's tenants by the entirety. Tenants by the entirety has to meet 4 conditions, which is called TTIP. TTIP, time, title, interest, and possession. So they took title by the same form through a warranty deed, inheritance, or tax deed, however they purchased it. They at the same time, exact same time, exact same day, they all went and signed together, and it's 2 or more people. And then they have the same percentage of interest. So each person has to, so here they mean percentage ownership interest, okay? If they're 4 people, each person owns 25%. If there's 2 people, 50%, 3 people, 33 1/3. And then the last one, possession, means they have 100% usage of the property. They possess 100% of the property. You don't divide it into 4 pieces and own 33% and 1/3 of each. They have possession of the entire property. So when they have to meet those conditions in order to be tenants by the entirety. If one of them dies, then that person's portion gets divided into all the others. The fourth one is tenants by the entirety. So that is for married individuals. It's for two people and they have equal ownership, same interest, 50-50. Now, in the state of Texas, we are a community property state. So it's a little bit different. However, you still have 50-50% ownership. But in Texas, it's called community property. In many other states, it's tenants by the entirety. Okay? And when one of them dies, their portion goes to the spouse. So it has survivorship. Doesn't mean survivorship of the heirs. It means the partner, whoever they're married to, survive, they get their portion. In tenants by the joint tenants, they also have survivorship. So whoever survives of the four, the one who passes away, their percentage get divided equally amongst the other three partners, okay? So that's a little bit different interest when it says just estate. So if you own property, you own part of an estate, you have a certain interest in the property. It could be rental interest, lease interest, a life interest, ownership interest, different type of definition for interest, separate than a percentage that you own, okay, of the property or of the ownership. All right, estate for years. So, okay, here, estate for years. A leasehold estate granting possession for a definite period of time. So an estate for years, like a lease, has a start and an end date, right? So leases for 1 year or greater, they have a start or an end date. Contracts have a start and a closing date. Listing agreements have a start and an end date of when they expire. Okay, that's a contract. So this is estate for years. First, they have possession, 100% use of that property for that period of time. Estate tax, federal tax levied on property transferred upon death. Okay, so I'm looking to the right because my other screen, okay, is where I am reading from, and the camera is right in front of me. So just thought I'd let you know. So federal tax levied on property transferred upon death. So estate tax. Estoppel certificate, a document that certifies the outstanding amount owed on a mortgage loan, as well as the rate of interest. So there's a couple different types of estoppel. There's estoppel when you're dealing with tenants, if we have a listing agreement and there are no leases between the landlord and the tenant, then we have to get some estoppel certificates that shows, you know, when their rent started, how much they're paying, and if it's month to month, or, you know, what the time frame is on it. This one has to do with owning a mortgage loan, okay, and at what interest rate. Et al, abbreviation for the Latin phrase et alias, meaning another. So, and when you become a realtor and you start looking, or some of you may be getting your broker license, when you look at the county appraisal's office, that is something that anytime that I'm looking up a property, I look up the estate. That is public information that anybody can go and look. So let's say here in San Antonio, it's Bexar County Appraisal District. And the other county where I also do business, Hidalgo County Appraisal District. So it's HCAD or BCAD. On there, we go and we look who the property is listed under, who the owners are. It tells us the current assessed value, the current appraised value, according to the assessor's office. And if it has more than one individuals and they can't list them all, okay, they won't show up. It'll say et al, meaning and another, okay? Et ux, abbreviation for Latin term et uxor, meaning and wife. Et vir, Latin term meaning and husband. So ux, wife, vir, husband, okay? Eviction, the lawful expulsion of an occupant from real estate. So expulsion, evict them, on getting rid of them, having them move from your property. If they don't voluntarily move at the end of the lease, then we have to go through an eviction process, file the right documents in the county court. When you're in small towns, you go to little county courts instead of major district courts. And so many cities or adjoining cities have smaller courts, okay, where you go maybe to the commission office. Those are a lot easier than going to the big courthouse. And I have experience doing both. I like the little ones better, much quicker, not as many people. So to evict someone, if you're ever going to be a landlord, you're going to invest in property, you may have tenants, and you have to know the landlord-tenant laws. And let me tell you, tenants are very savvy. They research it, they learn, and they know how to use the system. Evidence of title. A document that identifies ownership of property. Okay, a warranty deed. Okay, the title commitment that the title company searches, okay, is called, they search for the chain of ownership, okay, the history on that property. And so it's a document that identifies the owner of that property. They could have an equitable title, means they are buying the property, but they don't have legal title to the property. So they have equitable title, but it's still evidence, and they'll get the property once they pay off that loan. So it's not recorded under their name yet. Oh, sorry, guys. Let me put my phone on do not disturb. Excuse me for that. I don't like to be interrupted during class, and I forgot to do that. Okay. Examination of title, what I just mentioned, that once we have a contract, we send the contract to the title company, or we hand deliver it. The title company the escrow officer is going to order an abstract title, a research of that title, a search of that title to find out who the owners have been, if there's any liens, any judgments, any easements, any encroachments, anything like that will show up when they examine the title. And then that is delivered to the buyer and the seller, to the agents, okay, and to the owners, so that if there are any clouds on the title, then they'll be taken care of prior to close. Exchange, a transaction in which property is traded for another property rather than sold for money or other consideration. So sometimes individuals just want to do an exchange. Like, let's say I may have an apartment complex that's worth $500,000, and someone else that owns multiple residents wants to upgrade and purchase that apartment complex. So kind of like in Monopoly, right? In the game of Monopoly, you're buying and selling. First, you buy a lot, then you put a little house. After you have 4 little houses, then you trade those in for a hotel, and you get a little red one, right? The little houses are green, and then you get a red one. That's, a multiplex unit. So we're doing an exchange. It doesn't necessarily have to be a small property for a larger one. It can be an equal exchange. Exclusive agency listing, a contract between a property owner and one broker that only gives the broker the right to sell the property for a fee within a specified period of time, but does not obligate the owner to pay the broker a fee if the owner produces his own buyer without the broker's assistance. Okay, the owner is barred only from appointing another broker within this time period. So, you know what, I was going to ask if that screen is large enough. Maybe I should go to this. Okay, maybe that you can see it even better. You don't necessarily have to see me through the whole thing. Okay, so when we're doing a listing, we have an exclusive agency. Okay, and in that exclusive agency, there's 3 different types of listings at least. There's an open listing, which means we don't have a written agreement. There's a verbal implied agency with clients that we do repeat business. Then there's exclusive agency, as it is here, where we do have a written agreement with a seller. However, if the seller procures that buyer, we are not obligated to get paid. Okay, we don't like to do those, right? Our services are services that require payment. If it's a repeat client of yours and they've helped you a lot, sent you a lot of referrals, you may do that, okay? But your broker may end up wanting a certain percentage from you anyway, and the buyer agent still has to get paid. So there's got to be some commission involved in there. And however, if the owner brings the buyer themselves, there aren't any agents involved. The exclusive right to sell is the type of listing that we want to have. It's a contract between a property owner and a broker that gives the broker the right to collect a commission regardless of who sells the property, who procures the buyer. And it's between during a specified period of time, right, of the agreement. So listing agreements have a start and an end time. And in my case, I typically will ask for a 6-month listing agreement if it's residential. If it's land, 1 or 2 years. If it's commercial, 1, 2, or 3 years, depending on the type of property. But for residential, it's typically about 6 months. Some people will want 3. So regardless of who brings the buyer, the seller is obligated to pay commission to the buyer agent, to the listing broker. And that listing broker and the realtor will share their commission with the buying side. Okay, so, I've seen statements where on our MLS, we will have to specify where, how much commission is being paid to the buying broker. Well, some realtors, you may put on there 2%, 2.5%. Some buying agents want more money. And they say, well, my buyer is saying that seller has to pay 3%. Well, it's not up to the buyer, okay, nor the buying agent. It already says in the MLS that for this particular property, the owner is paying 3% or 2.5%. Let's say it's 2.5% to the buying agent. It's the seller who's paying that, not the buyer. If the buyer wants a certain amount of percentage to go to the buying agent, then they'll have to contribute the difference. And we as realtors, our interest is to get the highest and best price for our seller or to get the best and lowest price for our buyer, no matter the commission that is being offered. A question like that is telling me that the buyer agent is more interested in the commission than in just helping their client. They're being a little bit selfish. So we have to abide by what's on the MLS agreement. If somebody were to come to you and say, hey, you're offering 2%, but I want 3%. Well, sorry, it says 2%, and that is what you will get. If you want more, then you educate your buyer to do that difference of 1%. If not, move on, okay? It's just that black and white. Executor, executrix. A person named in a will to administer an estate. The court will appoint an administrator if there is no executor named. An executrix is feminine form. Like over here, we had ux. So when it ends in an X, it's a wife. It ends in an R, executor, it's a husband. Okay, executrix is the feminine. Executor is the masculine. So whenever there's a will, there will be an executor. If there is no will, the probate court will assign an administrator. Okay? Executory contract. A contract in which one or more of the obligations have yet to be performed. So a contract's been executed, like on our contract, okay, at the end of our contract, right here, okay, it has to be executed. So this is the executed date of a 1-4 residential contract. It's also included in all the other different contracts. But the whole process, the purchase and sale still has to be completely executed. Okay, so it hasn't closed yet. So that's called an executory contract, a contract in which one or more of the obligations have yet to be performed. Buyer has to go through their portion of it, right? In the, oh, they changed on here, but you know what? I scanned this and somehow I missed a couple of pages. So I'm going to have to rescan to show you guys more for a later date. Okay. So for today, I can't show you that portion. Well, I can on a different, but now the contract changed. We have a new contract as of April 1st. So the older contract has section 23, which is the option period. During the option period, the buyer is performing their inspections, their due diligence. Once the option period expires, okay, by 5 o'clock at the specified date, and that is time is of the essence, then it becomes, oh, during that portion of the contract, it is a unilateral contract, right? Only one person is performing, the buyer. Once that is completed, then it becomes a bilateral contract. Both parties have to perform. Okay, so the seller has certain specific performance. The buyer has specific performance. So the seller has to make the property available and be able to sell it, and the buyer following through. But there are many ways that a buyer can get out of a contract. For a seller, no, unless deadlines are not met and doesn't want to extend it, or it's an illegal contract, then they can void it. But when it's a valid contract, it's difficult for any owner to get out of it. Executed contract, a contract in which all obligations have been fully performed. So the contract that I mentioned earlier is all the signatures have, the buyer and the seller came to a meeting of the minds. So that is a legal contract that was executed. Everybody signed. The last realtor who gets a contract puts the date on there. Now the title company, the lender, everybody else knows. Now we have a contract in place, an agreement between the two, seller and buyer, and the whole process of closing can begin, and the lending process. Once it closes, then it's called a completely executed contract. So that's a little bit different. All obligations have been met. An express contract, an oral or written contract in which the terms are expressed in words. So some express contracts are valid. However, they won't hold in court because they're not in writing. Okay. Extension agreement, an agreement between mortgagor and mortgagee to extend the maturity date of the mortgage after it is due. Okay, so there's an agreement between who's the mortgagee and who's the mortgagor. Okay, so who just said hi, Lily, since I can't see your name? Buyers with limited cash. So who is that? Buyers with limited cash. I don't understand that comment. Or maybe you just said hi, Lily. Oh, okay, you have something else on your screen. Okay, so you have to give Facebook permission to use comments on StreamYard, okay? And it was, you have to go into this. So who was that said, hi, Lily? So you've got to go into this page, okay, StreamYard.com/Facebook, and give them permission so that you can post and see your name and your picture. Oh, it's the background of my screen that we see. Yeah, it says to buyers with limited cash. Okay. So whoever said hi and good afternoon, type your name. All right, let's continue on. Extension agreement. So if there's an oral contract, okay, make sure you get it in writing, especially when you want to get paid. extension agreement, you know, an agreement between the mortgager and the mortgagee. So nobody typed on here, who's the mortgagee and who's the mortgagor? Type on comments. Who's who? OR and EE. So I'll give you a chance. Nobody? Okay. Or is the lender. Not in this case. So in this case, the mortgagor is the borrower. This is one of the only cases that it's different. Trustor and trustee, same difference. A trustor is the borrower, and the mortgagor is the lender. Okay? I'm sorry, the mortgagor is the borrower, right? Because the borrower is giving payment to the lender, is also giving a deed to the lender in exchange for the money that they are receiving. So the mortgagee is the lender. The mortgagor is the borrower. You're welcome. So who is that just typed? Type your name, because I can't see your name. So that's the only thing that happens here when you're commenting. Okay, so this person said, yes, you're right. So I don't know who it is. Okay. External obsolescence, a loss in value of a property due to factors outside the property, such as a change in surrounding land use. So external obsolescence is impacted. Hey, Charles, nice to see you. So I'm using this new system, okay, StreamYard, and it allows me to broadcast to Facebook and also to YouTube. But you have to give StreamYard permission, or you have to give Facebook permission in order to see your name. And so you just go to that website really quick. You can do it while you're on here. I did the same when I was on another StreamYard call, and I gave Facebook permission, and then my name started to show, okay, like this. Of course, this is my YouTube channel, but that's my picture. So external obsolescence is also like environmental obsolescence. So no matter what you do to the outside, to the house, the property, the value is not going to improve because we can't change the surrounding. If there's an area that became commercial next to us, no matter how much we invest in the property to improve its value or bring it up to, a better appearance, excuse me, it's not going to improve because the adjoining properties are commercial, or a waste treatment, or an expressway, or a mall, or something else. Okay, industrial or agriculture. Well, the agriculture probably already would have been there. Okay, so there's nothing you can do to improve the value. So because of the changes in the environment, in the external surrounding areas, the property value will be depreciated. Okay. Okay, fair housing law. Very important that you all know these fair housing laws and the protected classes, right? So a term used to refer to federal and state laws prohibiting discrimination in the sale or rental of residential property. And so there are 7 protected classes that we cannot discriminate. So remember those 7 classes. I think some people remember them by using the acronym fresh corn. Okay. Some of them are repeated, but they type fresh corn, and that's how they remember. Fresh corn is an acronym for the 7 protected classes. Okay, so no discrimination. So in the word fresh corn, there's 8 letters, right? So one of them is repeated. The R, I think it is. All right. Federal Housing Administration. Know these acronyms, all of you. FHA, I'm sure Charles knows that and many, but Federal Housing Administration, FHA loan, an agency within the U.S. Department of Housing and Urban Development, HUD, Housing and Urban Development, HUD, that ensures mortgage loans by FHA-approved lenders to make loans available to buyers with limited cash. So buyers with limited cash are only required to put 3.5% down. And those loans are insured. They're insured for the life of the loan, and they are 30-year loans. Sometimes, other loans are less than 30 years. And if the person qualifies for an FHA and wants to put more down and have a higher loan payment, they can do that. Okay, a 20-year loan instead of a 30-year. However, FHA is an agency within HUD, Housing, Urban, and Development, okay? Insures, okay? So FHA insures. VA guarantees, right? So VA guarantees those loans are 100%. However, even on a VA loan, a borrower can pay some of their closing costs, especially in this competitive market. I had a VA borrower. We made 5 offers before we finally got one that worked. And they did not ask for buyer closing costs to the seller because 50% or more of the homes being purchased with VAs were not asking for buyer closing costs in this competitive market. When there are multiple offers, we have to have a very competitive offer. However, what I also learned with VA loans is that some of the closing costs can be added to their loan, and the property only has to appraise for the purchase price, which that's not doable on FHA. So that was something I learned this year. And I was talking to other realtors here in San Antonio, and they weren't aware of that. So it's something to know that VA will allow some of the buyer closing costs to be added to their loan if the seller is not willing to contribute to buyer closing costs. And it only has to appraise for the purchase price. That's the price that's on the contract. All right, some more acronyms. Fannie Mae, Federal National Mortgage Association. FNMA is an acronym. Know that. Federal National Mortgage Association, a privately owned corporation that buys existing government-backed and conventional mortgages. So this allows for banks to have more money to loan. So privately corporation that buys, okay, in the secondary market, existing government-backed and conventional mortgages. Government-backed, FHA is a government-backed loan, right? Federal Reserve System, FRS, the central banking system of the United States, which controls the monetary policy and therefore the money supply, interest rates, and the availability of credit. And right now, the interest rates are still really low. They went up a little bit, they went down, and even the stock market has been a little bit volatile, but interest rates are still excellent for buyers to buy. And that's one of the reasons we have a very competitive market in addition to a low supply of homes. So there's a high demand for homes and a low supply. Not everybody is wanting to sell right now, but a lot of people want to buy, right? It's cheap money. So fee simple, the best way to own a property. The most complete form of ownership of real estate. Fee simple. Freehold. It includes all the bundle of rights. Okay? So you also need to know what the bundle of rights are. I think another acronym for bundle of rights is Deep C. Bundle of rights. I believe that's it. So disposition, possession. I forget what they all stand for. So when in doubt, right, I look it up on Google. Oops. Okay, so what does Deep C stand for? Deep C in real estate. Oh, it's a Deep C acronym. Disposition, bundle of rights, possession, control, right of execution, exclusion, enjoyment, and disposition. Okay, so Deep C, you have disposition, exclusion, you can exclude whoever you want, enjoyment, enjoy the whole property, possession, and you have full control of the property. So those are the bundle of rights. Know them. And that's when they have a fee simple title, fee simple ownership. Okay, the best form of ownership of real estate. Okay, we're going to end the vocabulary there. So take a moment break. Okay, while I write notes. And let me know who's here. So I'm here. Hi, everybody. I'm having fun with this. So if at any point, okay, some of you can end up coming live, right? If we're doing a like a little webinar or joint. So I'm here. Okay, so who's this? I'm here. Okay, it doesn't tell me who it is. Maybe it does on Facebook, but it doesn't on here. And you know what? Let me look at my Facebook page and see if this is, it's supposed to be live on here, and it is. Oh yeah, so on Facebook, it does show the comments. Okay, so Leah is here, B more, Leah, Charles. All right, so that's what I need to do is put my Facebook, since I'm streaming to Facebook and to YouTube. On Facebook, I can still see, okay? So let me write notes as to where we're gonna start next time. So this is lesson number 33, okay? And so you see, I write my little notes of where I'm gonna start next week, okay? Because before that, I was asking students, hey, help me, where did I end last time? Okay, so we will start with FHA insured, right? And this is on page 164. All righto, so good. Any questions so far? Who's taking their exam? Anytime soon? So Leah, I'm gonna have to figure out Yeah, so for next time, you guys go into this link. So for future classes, okay, go into this link so that way during StreamYard, I can still see you on Facebook, okay? However, on StreamYard, it doesn't show your picture or your name. So if you can go to this link that you see on the screen, StreamYard.com/Facebook, give Facebook permission to post on StreamYard, and then I'll be able to see your picture and your name, whatever you use on Facebook. Okay. All right. So Leia's taking her class, her exam in about 2 to 3 weeks. Oh, you took it and you didn't do so well. That's okay, Leah. Don't feel bummed out. I know I was bummed out, okay, when I wouldn't pass. However, let me tell you, there are students that take it lots and lots of times. I know nowadays after 3, you have to take 2 more classes, or 1 for the state, 1 for the national. And so that's extra study time. However, whatever you do, think positive. You tell yourself, you're going to pass this. No matter what it takes, you're going to do it. Okay? So just keep at it. Practice, practice, practice. Keep doing it until you pass. It doesn't mean it's not meant for you, okay? Because you didn't pass. It might take you, 6 times, 9 times, 12 times. I've had students that have taken it that many times, and I've heard other realtors say they've taken it many times, and then they become awesome realtors, okay? Very successful realtors. So keep at it. Don't give up and don't beat yourself up, okay? That's what I had a tendency of doing. Okay, moving right along. So now we're going to go into, we're going to go into Kindle. And we're starting out with national question number 19 on page 130. Okay, go to page. It says page 130. Okay, national questions, and let me get my answers on page 239 on my other phone. Okay, so we're going to be on 119. All right. So let's get going. So is that screen size there okay? Or should I, let's see, it's more than just vocabulary. It is more than just vocabulary, Leah. You've got to practice it all. Vocabulary will help you answer a lot, but it's not just vocabulary that you need. You have to review lots of questions, national questions, state questions, continue doing it. I also had about 10 math questions. Most of my exam was on finance. Oh, most of your math was on finance. So practice the other ones, learn a little bit about finance. You're going to get help once you start the business, okay? However, learn some of your finance by doing questions and doing them on paper so that you can at least answer some of those. However, you can still pass without knowing the math, but you've got to know your other material well. Okay, so question number 119. Let me close. Oh, it is there. Let's see, how did I do it last time? Oh, let me see. Oh, here. I was viewing it a little bit bigger that way. Okay. So the distinguishing feature of a leasehold is, oh, you know what? I didn't show you guys what source I'm using now. So so that you all know in case you want to buy it. So this is the source that we're on now, Texas Real Estate License Exam Prep. I bought this in December. Okay, so this is a newer source that was just published in 2020. Okay, so it's a recent source. However, the contract just got changed in April. Okay. And again, this has an overview, national law review, all these sections here, legal sections are covered. And then you have real estate math cram cards review. So, you know, you're dealing with finance here. So here's a section on finance, but just about any review class that you buy or book, it's going to have these sections. And then Texas law and regulations, national practice test, and state practice test, and then it has the answer keys. Okay, so that's why I like this. Okay, so continuing on. So that's the source I'm using. The distinguishing, you know, what I don't like is this here. The distinguishing feature of a leasehold estate is A, ownership of an interest by a tenant. So remember, leasehold estate. So pay attention as to what kind of interest, because the definition of estate is what kind of interest they have. So it's a leasehold. So what are the features of a leasehold? A, ownership of an interest by a tenant. B, temporary ownership of the full bundle of rights in a property. C, unlimited ownership of one right in the bundle of rights in a property. D, that the estate is limited by a lease term. So we just covered the bundle of rights, what type of ownership that was. And so when you have a lease, do you own it or do you just have possession and the right to use? I'm chewing on ice. So remember to write the question, number, and the answer letter when you're typing your response. Okay, I have 119D. That's Leah. Thank you for doing that, Leah. Anybody else? Okay, so nobody else is taking a chance. The answer is 19D, that the estate is limited by a lease term. A says ownership. Well, when you have a lease, there's no ownership. B says ownership. There is no temporary ownership of the bundle of rights. It says of the full bundle of rights. No, you only get the full bundle of rights when you have full ownership, fee simple ownership. C says unlimited ownership. So no, they don't have unlimited ownership of one right in the bundle of rights. They have the right to use and possess. So they get to use two things. And then D, the estate is limited by a lease term. Okay. So 119D. Okay, so when I post it, is it going to show it on? Okay, so the answer is 119D. So I'm wondering if it's going to show my posting because I don't see it on on Facebook. So I just typed it on Facebook, but I thought it would also show it through what I type on YouTube. Oh, yes, you did? Okay. All right, number 20. A landlord conveys a parcel of property with the provision that the land cannot be developed for retail purposes. The new owner immediately begins to develop a retail shopping outlet. The grantor finds out and takes the property back. What kind of estate did this landowner convey? So the landowner is the grantor. Okay, so the landowner conveys a parcel of property with certain provisions that it cannot be developed into a retail business for retail purposes. Oops. So is it A, fee simple absolute, B, life estate with reversion, C, life estate with condition subsequent, or D, fee simple defeasible? Okay, so somebody said 120C. That was Leah. You know, when I type my answer on YouTube, it doesn't show it on Facebook. So I had to type it on Facebook myself. 120D, okay. So far C and D. Anybody else? Well, there's one other person on here. Well, 3 on Facebook, 4 on shows up on YouTube. Okay, the answer is D. They have a fee simple defeasible. And defeasible means if they don't meet the conditions of the landlord that conveyed it to them, it goes back to them. So those properties that it was conveyed to them, they have fee simple use of it. However, if they don't use it according to the conditions, then it goes back to the owner. So the defeasible fee estate is perpetual, continuing forever, provided the usage conforms to stated conditions. Essential characteristics are that the property must be used for a certain purpose or under certain conditions, and if the use changes or if prohibited conditions are present, the estate reverts to the previous grantor of the estate. So yes, it reverts, which, you know, on B it says life estate with reversion. But it's not just a life estate, and it does revert if they don't meet the condition. But the life estate with reversion is under other conditions. It means if they don't want it anymore, once they stop living in it for their life, they pass away, it goes back to the first owner. That's what life estate with reversion stands for. So that one wouldn't be. Life estate means they get to live there until they pass away. That's not the case here. So in fee simple absolute, it means that they have, you know, absolute usage of that property. There are no conditions. However, there are conditions that if they use it for other purposes, like a retail, it goes back to the owner. So the answer is D. So I've got to type my answers on Facebook. 20D. See, I like it. I like it when I do it here. So why? 1.20D. So that's the answer, 120D. Okay. Any questions on that? All right. Number 1.21. Ned grants his daughter Alice an estate for as long as she lives. Okay, I just talked a little bit about that, right? Her descendants, however, cannot inherit the estate. So what kind of an estate is this? Oh, C, So let's go back. Okay, Leah asked, life estate with condition subsequent. So it has certain conditions, okay, as to what the life estate was provided to them. However, the question says a landowner conveys a parcel, and so they didn't meet. They violated the condition of the land, right? They cannot develop retail purposes, and they were doing that. But when the landlord conveys it to another party, it's actually conveying full ownership of the property. So it is not a life estate. Okay, it's not a life estate with condition. It's a fee simple, defeasible, meaning it goes back to the owner. So it doesn't revert when the person dies, and it doesn't have certain conditions of what happens to the property when the person dies. Because a life estate means an individual is allowed to live there until they pass away. Okay? So it doesn't have other conditions. But so if we look at life estate with conditions subsequent. So let's read that completely. So fee simple subject to conditions subsequent. The estate is similar to fee simple, but has a condition attached. Established by conditional language, these estates are followed by a right of entry. If the triggering event occurs, the holder must take steps to establish possession of the land. Let's see here. Fee simple subject to condition. Let's see. When the words of a grant support the conclusion that the grantor intends to convey a fee simple absolute, but has attached a condition to the grant so that it is specified. If a specified future event happens, the grantor will get its fee simple absolute back. Okay. So it is simple. It is similar. It is similar to fee simple defeasible, which the owner is going to get it back, but it's not a life estate. Okay. This is saying the kind of conveyance that this owner did was a fee simple conveyance. They conveyed all the rights. Okay. They conveyed all the rights, not just a life estate. Okay. So a conditional life estate, ownership in which the owner does not have full right to the property because it is an estate. They have an interest to use it and have all the other possession rights, but they can't sell it. They can't encumber it. They can't do anything like that to it, but they could acquire full ownership if certain conditions, specific conditions are fulfilled. The ownership is conditional on those conditions. For example, George is the alternate remainder beneficiary. That would mean it has a remainder man, what they call. If the person passes away, the condition is that property will go to a third person. It doesn't revert back to the original person. So it says alternate, for example, George is the alternate remainder beneficiary of his mother's life estate, also called contingent ownership. So you see how it says here, fee simple? It was not a life estate. It's a fee simple estate. And the answer there, although you said, okay, Leah, B and C said life estate. That's until they pass away. When a landowner conveys a property and grants it or they donate it, it's like they're donating it, but it has to meet those conditions. So they're basically gifting it to them, but don't use it contrary to what I said. It's not until they die. It'll go on forever. Okay, pass away. That's right. So life estate is when they pass away. Okay. Okay, 21. Ned grants his sister Alice an estate for as long as she lives. Okay, so here's another one. an estate for as long as she lives. Her descendants, however, cannot inherit that estate. Why? Because it's only until she lives. So what kind of estate is that? She doesn't own it. A, an estate per atra v. B, an estate for years. C, an ordinary life estate. D, a legal life estate. So what kind of an estate is it? She grants her sister, Alice, an estate for as long as she lives. So what kind of a life estate is it? I'm sorry. Oh, gosh, I gave you an answer. What kind of an estate is it? I gave you a keyword, so that narrows it down to 2 answers, C or D. Okay, Leah says C. Okay, so far so good. Charles says D. No, it is C, an ordinary life estate, because it's going to be done legally. It could be done verbal, however, it's going to be done legally typically, right? Put it in writing. Cover your you know what. So 121C. I got to figure out this another time. Way to go, Leah. Okay. Number 22. Homestead. Homestead estates are examples of what? A conventional life estate. B, a legal estate, life estate. C, an estate created by an owner's agreement, or D, a fee simple absolute. Hey guys, I need to take a break real quick, so work on that, and I'll be right back. Okay, I'm back. You know, I love this working out of my house and having all my equipment in front of me. I wish I could show it to you. I have 3 monitors, a ring light, 2 phones, you know, going on. And it's practical, right? Okay, so what answers? Nobody answered? Hey, Jojo. Been missing you, girl. Welcome to the class tonight, the review. Okay, so nobody wrote down an answer? Come on. Homestead estates are examples of what type of ownership. So I made a comment earlier that all estates are legal. Well, there is such a thing as legal life estate. Okay, Jojo says A, conventional life estate. So let's look at the difference between conventional legal estate. I love this Google, man. Get to see it right away. Okay. So a legal life estate, legal life estates. While conventional life estates are created by the actions of a grantor. And who's the grantor? The owner, the seller. Legal life estates are created automatically by law. Originally, they were intended to protect the interest of a non-owning spouse upon the death of an owning spouse. Okay, so a legal life estate created by the law, right, to protect the spouse or other owner. So the conventional is created automatically by the grantor, but in the case of, and so the grantor conveyed the property, right, sold it, alienated it, conveyed it, transferred it, however you want to call it. It has many different names on how a property is means conveyed. Legal life estate created automatically by law, not just by a recorded document when an owner grants a property or conveys it to somebody else. It's the actions of a grantor. However, legal life estate, originally, they were intended to protect the interest of the non-owning spouse. So if a spouse passes away and the state says whatever was owned by the spouse that passed away goes to his wife or husband, then that's how it's protected, by that legal life estate. So somebody else doesn't come and take over it. Especially if it's a homestead, right? Or that's one of the conditions. Let's see here. So here's another. So if that one's not clear, so legal life estate is created by statute, while the conventional life estate is created by a grant. So a grant, the grantor conveyed it, okay? The legal life is created by the court. So conventional focuses on protecting the rights of the surviving family members, while the legal life estate focuses on laws of descent. Okay. So number 22, okay, was what? Nobody else took a risk, huh? Number 22 was B. A legal life estate, because it's what? Protected by a homestead. So that's a legal law that we can only have one homestead. So Jojo, you were close. However, the correct answer, and fee simple absolute, you know, it's a type of, yes, ownership. However, on the legal life estate, they had the right to live in it until they die, and the one spouse passed away. So now when the partner passes away, they now have fee simple absolute, but at the moment they don't. So the homestead estate, what we get in Texas or through the US that we can have one, is an example of a legal life estate. we have to announce that that is our homestead. If we don't go and report that it is a homestead, we don't get the what do they call it? The exemptions. However, when it's our primary residence, it's automatically our primary homestead. Okay, legally, that is our homestead. We don't have to record it as such because it is our primary residence. We have fee simple absolute. However, an estate is when you are allowing somebody an interest, right, on the use of the property. And so when someone dies, the spouse is protected by the legal life estate for nobody else to take over that property because that was their primary residence. Now, if they want to get the exemptions, okay, of a homestead ownership when you turn 65 or when you have 100% military disability, then that has to be recorded in order to get those exemptions. However, homestead is automatic if it's the only primary residence that they have. And whenever we purchase a property, the lender's going to ask us, is this going to be your primary residence or are you going to occupy it? If you say no, then more than likely it's going to be an investment. Okay, then it is no longer a homestead. Okay, did I write the answer? Yes, 122B. All right, number 23. So oops is okay, Charles. All right, 23. Louis owned a boat and a house before marrying Barbara. While she was single, Barbara owned a new car. The two got married and bought a second home. As a wedding present, Barbara's father bought Louise a motorcycle. Under the law of community property, what property can Louis sell without his wife's consent or signature? So Louis owned a boat and a house before marrying Barbara. While they were single, Barbara had a new car. The two got married, bought a second home. So now that is community property, the second home, right? Anything they owned prior is not community property. As a wedding present, Barbara's father, okay, bought Louis a motorcycle. So that was what, a gift, right? So under the law of community property, what property can Louis sell without his wife's consent or signature? A, the boat and house, which he owned prior to marriage. B, the boat, house, and motorcycle. He was gifted the house. C, the second home and the motorcycle. Or D, the boat and motorcycle. So what properties does he legally own that he can sell? Okay, Leah says A. Remember, one of the exemptions of community property, there are certain exceptions, not exemptions, exceptions to the rule. We talked about some of those exceptions last week, and I got one of them. I learned something new on one of them. Okay, so let's see, so far, what do we have? So we have 23A, 23A, 23D. I hate to disappoint you. The answer is 123B. Okay, so he owned the boat and the house. That he can sell on his own. Okay, so at least A would have been one that's correct. However, he was gifted the motorcycle, so that's his. Anything that is gifted to us belongs to us. It is not community property. Okay, if you have a personal injury insurance and you're in an accident and you get that insurance, that belongs to the individual. So gifts, personal property, personal injury insurance, those are exempt. Okay, those are exceptions to the rule of community property. Those belong to the individual. So the correct answer here is B. He owned the boat and the motorcycle and then was gifted the house. So all three, the boat, the house, and the motorcycle, he can sell without her consent. Okay. So 123B. Oh, I didn't make the other one. So 122 was B. 121 was C. I just wanted to make sure. Okay. Okay, so hide. All right, so number 24, and that'll be the last question for tonight on national. You're welcome, Charles. Okay, number 24. Remember, these are national questions, all of you. Caitlin rents an apartment for 1 year. What rights has she acquired under the leasehold? A, the right to exclude everyone from the premises. B, the right to encumber the fee interest. C, the right to sell the premises. D, the right to possess and use the premises. So remember, there are certain rights that we have access to. There's the fee simple rights when we own the property, bundle of rights. However, when you're a tenant, which rights are included? Let's go back to the question. Why isn't it moving? So what rights has she acquired under the leasehold? The right to exclude everyone from the premises. B, the right to encumber the fee interest. The right to sell the premises, or the right to possess and use the premises. So Charles says D so far, and so does Jojo, and so does Leah. And voila, 24D is correct. They have the right to possess and use the premises. They don't have the right to sell nor to encumber it, meaning they can get a loan on it. And they can't exclude everyone. When the owner gives them a notice to enter the property, they have to let them in, okay? A landlord has to follow certain rules in order to enter the property, so they can't exclude everyone. Yay, awesome. Okay, so 124. 124D, okay. 124D. Okay, so that's the last answer for the national tonight. So let me write my notes of where we start next week. All right, so that was national questions on the second book. So we will start with number 25 on page 131. And the answer's on page 240. Okay, and so with state, we're going to start on question 16.6. On page 219. Right there. Okay. Oh, I should have bookmarked the other. That's all right. I've got it written down in my notes. And page 1219. Okay. So the topic that we're on for state is special topics in Texas real estate. Okay. So these special topics in Texas real estate. So that's the types of questions that we are going over, starting with 16.6. Oh, darn it. Hold on. Page 2. 291. Oh, that didn't work. Okay. You see how I'm watching on this phone? Okay. I see the answers. And then on this phone, I get to see that Facebook is working. I tell you what, man, it's a good thing I'm partially techie or somewhat techie or actually techie. Okay. But there's always room to learn and improve. All right, let me change the screen. All right, number 16.6 on state questions. And this is special topics, okay? Okay, number 16.6, following the tax sale in a foreclosure proceeding. So this is following tax law in Texas. A homeowner, a foreclosure law and tax sale, a homeowner can regain full ownership of the property by paying all amounts owed plus fees and charges. In this scenario, which of the following is true? A, the homeowner may do this since he is exercising his equitable right of redemption. B, the homeowner may only exercise the statutory right of redemption prior to the tax sale. C, the homeowner may in fact exercise this statutory right of redemption provided the property is the principal residence. And D, the homeowner may exercise the statutory right of redemption provided it is done within 3 years of the tax sale. So you need to know your tax laws here, foreclosure laws for tax sale in the state of Texas. Every state has their own. So what can a homeowner do? Okay, they do have redemption rights. So what redemption right do they have? Do they exercise their equitable right of redemption? Equitable right means they don't have the title anymore, right? B says they can may only exercise a statutory right of redemption prior to the tax sale. So here's another little keyword, may only, okay, exercise, so little keywords to pay attention. C says homeowner may in fact exercise this statutory right of redemption, provided the property is the principal residence. Okay, they all have the word may in it, so that's not a trick word. The last one says they may exercise it, but within 3 years. State of Texas has a statute of limitation for redemption. So which one is it? Somebody said, thank you, Lily, but I don't see the answer on Facebook. Oh, probably because they're posting on YouTube. No, they're actually on Facebook. But that didn't show up. Okay, so far, let's see. Charles says 16.6, and he's watching on Facebook. So basically, everybody here is watching on Facebook except for moi. You know, when I do this, that's because I have it going. So Anybody else besides Charles? Hey, did you all notice here I have a Wild Lily Handy? That's my nickname with EXP. I'm known as the Wild Lily Handy. My car, while you're thinking about the answer, my car used to, a little car, Mercedes that I bought, I was gifted, okay, in 1998. The license plate said Wild Science. And it was an acronym, YLD SCI. Why? Because I'm a scientist, right? I was an engineer. So, I've always said I was wild. So now in real estate, since I moved to EXP, I'm calling myself Wild Lily Handy. It's cracking people out, but that's going to be my brand. In addition to wearing my EXP hat, I love EXP. Okay, any answer? So I've got a C or a D. Anybody else? Well, there's only 2 of you on here. Never mind. So the answer is C. The homeowner may in fact exercise their statutory right of redemption provided the property is their principal residence. Okay, so they get a 2-year right of redemption when it's bought at a tax sale, and unless it changed anytime recently, the first year they don't redeem. If they redeem it the first year, they pay 25% interest in addition to whatever is owed and fees, right? Because down here it says a homeowner can regain full ownership of the property by paying all amounts owed plus fees and charges, okay, interest charges. And the second year, they would have to pay 50% interest on that balance that they owe. So that's why investors like to pay this. They can't sell it. They can't convert it. They can't build on it. However, they can rent the land. They can rent the house if that's there for those 2 years and then return it back and make 25% interest on what they paid or 50% interest. Pretty cool, huh? That's what some investors do. I looked into that, but I'm like, no, that's not what I'm doing. I like to buy and hold property. So that's the answer. And do a little bit of repair, cosmetic stuff, nothing major, because I want the most profit. 16.6. What was the answer? C. So I bought different properties, commercial property. I bought one, and then land and rentals, and one rehabber that I never did anything to it. And in 1 year, I made 30,000 profit in Oregon because the market was going up like crazy. And I was embarrassed to put it on the market, right? Never be embarrassed about your investments. And then I buy properties with no money down and sell them on owner financing. I take over the loan for some people and then resell it on owner financing and then sell them like 5 years later or 10 years later. So that's some of my real estate experience on the investment side, if you ever need help. Okay, that was number 16.6. So number 7. Which of the, so did you all get that? Remember those rules. 2-year redemption in Texas. And it has to be your primary residence. So which of the following agreements are enforceable? A verbal 30-day month-to-month lease. B, an oral agreement to buy an oil interest in a property. C, a written lease signed by the landlord's son, an unauthorized representative. And D, an oral property conveyance between a judge and a juror. So which of the following agreements are enforceable? It's 2 years, Leah. The question said, the answer, one of the answers said 3 years, but that answer was wrong. Unless they changed it, but my last experience on the state of Texas, they have a 2-year redemption. Okay, so which of the following agreements are enforceable? A verbal 30-day month-to-month, an oral agreement to buy an oil interest in a property, a written lease signed by the landlord's son who is unauthorized representative, or D, an oral property conveyance between a judge and a juror. Okay, yes, right. I got to figure out how all comments can be shown up on the screen. Because you all are seeing the comments on Facebook. Are you seeing the StreamYard? Yes, you see the StreamYard. However, you don't see what's on the right screen of the comments that people are writing. You see the comments that we're writing on Facebook. Or I'm not sure. Anyway, I have to research it a little bit more. Okay, so we have an answer of A and A by Charles and Leah, which are my two faithful, yes, a verbal 30-day. Do you know why? You must know why, because you got it right. Seven. So type on there on comments why that one is correct. Okay, well, because any agreement, any lease that's less than a year or less, okay, will stand in court. Okay, so a lease for less than a year or less is legal. Okay, if it's more than a year, it has to be put down in writing. Okay, number 8. 16.8. Which of the following is a legitimate power granted to a landlord or a tenant? I knew what it's not. That's good, right? Hey, sometimes we guess right? And you know the others were not, right? Okay, so which of the following is a legitimate power granted to a landlord or a tenant? A tenant's right to vacate, week rental with a lease at least 1 day, actually a year or less doesn't have to be in writing. If it's more for a year, then it must be in writing. So A, tenant's right to vacate a week-to-week rental with at least 1 day's notice. B, a tenant's right to apply the security deposit to the last month's lease in the absence of damage. C, a landlord's right to evict month-to-month lease tenant with a 30 days advance notice. Or D, a landlord's right to waive liability for not maintaining habitability of the premises. The answer was 16A. Yeah, I don't show the answers on, I mean, we type the answer, but we don't show all the answers. Can't see answer A verbal 30-day month-to-month. Oh, okay, you can't see answer. Oh, I see. Yeah, hold on. Okay, you should be able to see it now. I had to get rid of, maybe they're better. A, tenant's rights to vacate a week-to-week rental with at least 1 day's notice. B, a tenant's right to apply the security deposit to the last month's lease in the absence of damage. C, landlord's right to evict month-to-month lease tenant with 30 days advance notice. And D, a landlord's right to waive liability for not maintaining habitability of the premises. So which one is it? So I can't see anybody writing comments. So nobody has answered. Okay. The answer is 16.8C. So landlord's right to evict a month-to-month lease tenant with a 30 days advance notice. Almost every state that I know of, well, I haven't had leases in many states other than Texas and Oregon, but it does require 30 days advance notice. Some are now requiring 2 months advance notice. Okay, good job. No, a tenant can vacate a week-to-week rental because they have already an agreement. It's week to week. So at the end of the week, they're gone. They don't have to give a 1 day's notice. Boy, it got warm on me. Oh, I have the door open for my kitty cats to go out. And my fan is off. Sorry guys, but I'm getting warm here. Okay, did you guys get that? Did you guys and gals get that? All right, number 9. Which of the following is true regarding subletting a rental property? Subletting a rental property. A, tenant may freely assign unit if leases for more than 5 years. B, tenant may assign or sublet but must return property to original condition prior to the subtenant's occupancy. C, tenants are free to assign their lease obligations but may not sublet without the landlord's permission. D, tenant must obtain landlord's prior consent to sublet the apartment. So a lot of tenant and landlord right laws here. So I don't know if I showed this one. Okay, Leah says D. Tenant must obtain landlord's prior consent to sublet the apartment. Anybody else? So yes, the answer is D. Tenant must obtain landlord's prior consent to sublet the apartment. Without exception, tenants must obtain the landlord's consent prior to assigning or sublet their lease hold interest. Okay, it is not, however, always necessary to return the premises to its prior condition before sublease effective date. So the lease agreement may already specify that they can do that. So very good, Leah, 16.9D. All right. Number 10, which of the following is not a landlord justification for keeping a tenant security deposit? So talking about security deposits, okay? A, to eliminate normal wear and tear to the apartment, including painting and carpet cleaning. B, to offset rent allowed by the vacating tenant. C, to repair damage to the plumbing system. Or D, to cover excessive damage caused by a dog, even though dogs are permitted. So which of the following is not a landlord justification for keeping a tenant security deposit? Hi, Elizabeth. We're doing state questions right now. Thank you for joining us. So we're on question 1610. So to eliminate, which of the following is not a landlord justification for keeping a tenant's security deposit? Normal wear and tear to the apartment, including painting and carpet cleaning, offset rent owed by the vacating tenant, C, to repair damage to the plumbing system, or D, to cover excessive damage caused by a dog, even though dogs are permitted. Okay, come on, give me some answers. There are 3 of you on here. And while you're on here on Facebook, remember to like the video. Well, some of you are writing comments, right? But the others. And if you ever get on YouTube, like the YouTube video or the YouTube live, I should say. No answers? Nobody's answering yet? All right, moving on. The answer is 16A. So normal wear and tear to the apartment, including painting and carpet cleaning, that's a normal expense for an investor that has an apartment. That's included in maybe a non-refundable fee, a non-refundable deposit, or, it has higher rent to cover for that kind of thing. Yes, but it has to state it in the agreement, Leah. Okay, I also used to charge, and it'll state you have a non-refundable deposit. Okay, and so here it doesn't say that it's a non-refundable deposit. It says a tenant's security deposit. So security deposit is typically not used for that unless it's specified in the lease. The lease also has a section where you will say deposit for cleaning and any other types of thing is not refundable. So there can be a deposit for after moving out, and that is maintained by the landlord. But it has to be specified on the lease. They can't just take that from your traditional security deposit. Okay. All right. Number 11. In maintaining proper relations with tenants, landlords and tenants are obligated to meet certain apartment security standards. Which of the following accurately identifies one such standard? A, tenants may alter security devices, but at their own expense. B, landlords must install window locks in occupied buildings. Tenants must install security bars for glass doors. C, all security devices must be repaired within a 30-day time frame following tenant's written notice of the disrepair. D, the landlord must rekey the locks within 7 days following a tenant's vacating. So go back and read the question. In maintaining proper relations with tenants, landlords and tenants are obligated to meet certain apartment security standards. Which of the following accurately identifies one such standard? Tenants may alter security devices, but at their own expense. B, landlords must install window locks in occupied buildings. Tenants must install security bars for glass doors. C, all security devices must be repaired within a 30-day time frame following tenant's written notice of the despair. And D, the landlord must rekey the locks within 7 days following a tenant's vacating. Okay, Leah says D. I have 1611D by Leah and 1611D by Charles. And that answer is correct. So YouTube AgentPrep is actually me, right? Because this is being also broadcasted on YouTube. That was number, what, 11? So this is cool, this StreamYard that I purchased. So on your top of your screen, you can see on the Facebook, it says StreamYard on the upper left. So I wonder if you click on that, if it'll automatically let you go to, dang it, where's my mouse? Oh yeah, I think you could be able to click the little duck up there and sign up to have it approved. Yeah, I like it. Cool, huh? It's a better view, right? Thanks, Leah. So you guys will have to try it out on YouTube one of these days. Okay, so the answers are on both of it? Yes. Okay, number 12. Texas Property Code Chapter 92 is very specific about fire safety regulations. Oh, I didn't read the answer, right? The answer was D. The landlord must rekey the locks within 7 days following a tenant's vacating. I guess if they're going to re-rent, but what if they're not going to re-rent? But typical. So on a standard situation, they must rekey within 7 days. If they're going to rent it in less than 7 days, then they got to rekey it right away. So number 12, Texas Property Code Chapter 92 is very specific about fire safety regulations. According to the code, A, there must be a smoke alarm on at least the ground level of a 2-story duplex. B, fire alarms must be inspected annually by the landlord. C, tenants are responsible for inspecting and repairing fire extinguishers. D, there must be a smoke alarm in every bedroom of a dwelling unit. So think common sense. So if you're on a 2-story building, fire rises really quick, right? So the people on top are going to get smoke. So do you want to have smoke detectors just on the bottom? Okay, so far we have 12D. And that's Leah. Okay, there's only 2 of you here, Charles and Leah, I believe. Yes, correct. That answer is D, there must be a smoke alarm in every bedroom of a dwelling unit. Very good. Okay, last question for tonight. Utility service to tenants is regulated by Property Code 92. One of these regulations is that A, tenants are responsible for all utility charges if the apartment lease exceeds 1 year. B, tenants may not pay a landlord's utility bill to avoid any service interruption. C, the landlord may not cause utility service to be interrupted to the tenant as a means to collect unpaid rent. And D, if a tenant is forced to pay landlord's water bill for the apartment, the tenant nevertheless must continue to pay rent in full. So which one is the best answer? Okay, so far I have one C, actually two C's. All right, Charles and Leah. So yes, the answer is 1613C. Awesome. Which is the landlord may not cause utility service to be interrupted to the tenant as a means to collect unpaid rent. However, you know what? There are some landlords that do that. They work through intimidation and tenants get scared and don't, say anything. However, there's a lot of experienced and educated tenants out there that know the law, and boy, they can create a lot of problems for landlords. So that was it for the questions for tonight. Awesome. So Leah, so why did you like this StreamYard better? Even though it's being broadcasted through Facebook, does it look clearer? Does it, why do you like it better? So now I can show you my face and you can tell me a little bit as to why you like it better. So you'll have to, of course, comment, right? So while you write those comments, I'm going to write down where we start next time. So see, I'm always trying to do something to improve the class. You should have seen how I started Facebook several years ago. It was funny. Some of those videos are posted on Facebook on the list of videos. So page 220. It's different. I can see your face. It's clear and some answers pop up. Oh, okay. When you say some answers pop up, well, oh, that's my 8 o'clock unwind alarm. I have an 8 o'clock on my phone. Tell me, oh, it's time to unwind, Lillie. So yes, on here, there were times where I did Zoom, okay, on Facebook, but nobody wanted to attend it and it was costing me quite a bit. Nobody wanted to get on Zoom and have a two-way, because that way you would help me read some of the questions. We would take turns and I wanted that participation. However, that was before COVID and it didn't go over well. So I was making an expense that nobody was utilizing. So with StreamYard, it's a lot less expensive. However, it's like a webinar. Now you can see me, you can see my screen. So, the comments pop up and that's because I'm clicking on them. Is that the comments that you're talking about? The ones that that say, like that one that I just put that says YouTube, okay? And then I click that one. So I'm having to click every single comment. And so I'm still learning, okay? Compared to on Facebook, right? On Facebook, they're just on the little comment screen. So I'm going to learn to see how I can get these comments to show up automatically instead of me having to click every one. So if somebody shows up on YouTube, I can see their comments. If somebody shows up on Facebook, I can see their comments. And I think I have to do it. So this allows me to broadcast to multiple media and have it recorded on multiple media. However, on YouTube, I like to divide it into 3 different videos, right? The national. So if you've been in my YouTube channel that I created in November, I divide this 2-hour video into 3 different videos. One is the the vocabulary, and then national questions and answers and state questions and answers. That takes time because I have to download the video, upload it into an editing software, and then split it into 3 different videos, put an intro, an outro, then download that, and then do the same thing to the other 2. So it takes a lot of work, but I'll tell you what, it's an awesome experience of what I've learned. So I'm going to see this experience now on YouTube and see how it shows. It's going to be the whole entire class, but I'm still going to provide the division. And in some of my initial videos, I used to have background music, right? And so I get comments of people saying, oh my gosh, the noise is terrible, it's loud. And yes, well, I was learning, I was experimenting. There was a script showing everything you said, which was also good. Yeah, that shows up on Facebook. It doesn't show up on here unless I figure it out, but it is showing up on Facebook because I've got my, okay, see, I've got my Facebook screen on my phone, okay, while I'm doing this, and it shows up on there. So I'll see if it can also do it on YouTube through StreamYard. And then I had the other phone that has the answers, right? So I've got all these devices going on. I guess from now on, I could put the answers on another TV screen because I have 3 monitors. And I have a setup where I have my Microsoft Surface Pro here in the center and a docking station. And then I have 2 monitors, one on the left, one on the right. And then this back here is my green screen. So whenever you get into creating videos, okay, and recording, you'll want to have a green screen because then I can change the green screen, okay, and put different backgrounds and some B-roll. Okay, Charles, thanks for attending. Talk to you next time. So, hey, I've gotten techie here to create videos, learning a lot. So anyway, Leah, I wish you a lot of luck. You can always contact me, okay, if you want additional help, okay, on text, on email, probably texting, and I can get to you much quicker. All right? So, hey, all, hope you all enjoyed this class. Today was lesson number 33. I go consecutively from these books that I'm using. So when you watch one of my prior videos, look at the number on the lower left-hand corner on the thumbnail. I've only posted 5 through 10. As I was saying, it's a lot of work. So there are a lot of videos. I may have to hire somebody to help me with dividing them and posting them on YouTube so that I can have them all and have a better quality. But this will be completely all on there. You're very welcome, Leah. And I appreciate you all. So for next time, go and have Facebook approve Facebook, okay, to let you comment. And so the comments will show on here and it'll show your name and it'll show your picture like it does on Facebook. Facebook has now protecting everyone and has to know that you're allowing permission to be posted, okay, on StreamYard. It can't just automatically do it. So that's a relationship between StreamYard and Facebook. Okay, so Facebook protects individuals a lot. All right, so It was fun. It was great. Now I get to see, your comments on 2 different media, and you get to see a little bit of me. So catch you later. Until next time. Bye.